and welcome to the 4th Annual Corporate Crime, Compliance, and Investigation Symposium from DLA Piper. My name is Regan Christensen. I'm a lawyer from DLA Canada in the Calgary office, and have with me this morning a fantastic panel of 3 panelists who are going to be speaking with us about navigating challenges in complex investigations. So without further ado, allow me to introduce our panelists. I have here with me Jordan Deering, who is also from DLA Canada in both our Calgary and Toronto offices. She is the chair of DLA Piper Canada's Corporate Crime, Compliance, and Investigations Group. She's also a partner. Her practice is focused on litigation, investigations, and regulatory proceedings involving all aspects of fraud and corporate misconduct. She regularly acts for financial institutions and for corporate clients in respect of sensitive, high-stakes mandates. We also have with us this morning Michelle Morgan, who until very recently was a partner in DLA in the United States in the White Collar and Government Investigations Group. Michelle is now back on the government side of things, where she's an assistant United States attorney in the U.S. Attorney's Office for the District of Delaware. She's practiced in multiple jurisdictions, handling both criminal and civil matters in public and private practice, which is going to give her some great perspective to add today. And as a federal prosecutor, Michelle has broad experience conducting complex cross-border investigations and interfacing with an extensive number of federal and state government agencies. And finally, from the other side of the Atlantic, we have Pragesh Sivaguru, who is an associate joining us from the DLA Piper UK part of the firm, located in the London office. He often advises financial institutions, trading firms, and payment services, complaints, and internal whistleblower investigations. Looking forward to having his perspective as well. So throughout our time together this morning, we do invite you to put any questions you may have in the chat, as we want to be responsive and get back to you, whether that be during the session itself or perhaps after through email. So today we're going to proceed in essentially 5 sections. We're first going to have a discussion about planning our investigations. Then we're going to have a little chat about privilege. I know we've got another session coming up later on in the month that's going to dive into that in more detail. However, that is an important topic and will be layered in throughout today. Then we'll have a section on data preservation and collection of records, followed by a section on actually conducting interviews, with our last section being on reporting, self-reporting, and a little bit about whistleblowers and programs available in that area. So why don't we dive right in? Our first section, of course, is on planning the investigation. I think it goes almost without saying that if you want to have a successful investigation, you need to have a clear plan of action for success. So we'll start off with Jordan. As part of determining the scope of an investigation and developing a plan, what are some practical considerations that need to be considered right from the start?
Yeah, thanks for your question, Regan. And in typical panelist fashion, I'm not exactly going to answer your question. I'm going to answer something else and then answer that question. So the first thing I'm going to say is, even before we get to the question of scope and a plan, I think we need to ask, do you even need to conduct an investigation? There's been a lot written lately, especially here in Canada, about debating, are we over-investigating things? Everything gets an investigation. Some people have complained nowadays. And I think that it's fair to comment that some minor complaints probably don't need a fulsome investigation, and they don't need the company resources, time, effort, and adverse consequences that can come out of conducting an investigation. So I think it's worth giving some pause and, just stopping to say, okay, do we actually need an investigation? So what are some factors to think about as to whether or not we need an investigation? In some cases, it's mandated by law. I'm thinking here about, for example, the occupational health and safety legislation. If you've got a fatality or serious injury at the workplace, you are required to conduct an investigation. So that you would have no choice. You must conduct an investigation. If you're dealing with instances of very serious misconduct, fraud, bribery, corruption, serious conflicts of interest, violations of criminal laws, I would say you certainly need to conduct an investigation into something of that level of severity. If senior members of the organization are involved, your C-suite, your president, you probably need to look at those types of allegations a bit more carefully. And I'd say if the regulator or law enforcement is going to come knocking at your door anytime soon, you certainly need to get ahead of that and start an investigation. So just a few things to think about before we all start making a plan is whether or not you need one at all. But getting back to your question, Regan, once we decide, okay, we're going to conduct an investigation, you certainly need a clear definition of your scope. I think we've all seen investigations, whether that we've conducted or we've been watching from the sidelines, where the scope has slowly started to creep beyond the original plan. And sometimes that's necessary, but my point here is that it should be thoughtful and it should be considered, and you should be assessing whether or not this increase in scope is appropriate and warranted and what that means to your plan. You certainly shouldn't let that scope start to spiral out of control, and you finish this investigation and you're not even sure where you started and why you began this adventure. So it's really, and it's easy for it to happen. I'm not being critical of when it happens, but it's just something to really keep mindful of. And that's why I think preparing and having an investigation plan is so important. It's going to set out your scope. It's going to keep you aligned as to what your task is. What are you trying to assess in this investigation? And it's also going to start thinking about things like what you need to do that investigation. Who's going to be involved? Who shouldn't be involved? Who do we need to keep away from this investigation? Who do we need to talk to? What are the documents we need to be looking about? And where are all the potential landmines that we need to avoid? And we're going to talk about a lot of those challenges today, but you should be starting to think in your investigation plan, where's the trouble points here and where could we run into trouble? The last thing I'll say about planning an investigation is that you're never done planning an investigation. So, we lay out our wonderful plans at the very beginning, and then of course, everything changes, right? So I think, certainly we need to respond to that change, but we also need to go back to the plan and think about for a moment, how does that change what we're thinking about? How does that change the trouble spots? How does that change the order of our interviews, the documents we're looking at, all of those different things? So I think it's always important to go back to that investigation plan at regular interviews and do a bit of a check-in.
Wonderful. Thank you for that, Jordan. Turning over to Michelle, why don't we chat a little bit about the composition of the team doing the investigation? So Michelle, what are some of the key considerations that you have when you're, of course, on the private practice side of this doing the investigation? Because we're talking mostly to, I think, clients and organizations here. But what are the key considerations determining the members who make up that investigative team and their respective roles?
Right. So when you're starting to put this together, you want to think about, initially, the question is always, is this going to be done by outside counsel or is this going to be done by inside counsel? And there's always a debate because obviously the company wants to save money, right? There are certainly strong reasons why, setting aside the financial considerations, it's often appropriate for outside counsel to do the investigation. And one of the biggest reasons is the attorney-client privilege issues that might arise. And we're going to discuss that as a separate topic in a few moments. So I don't want to get too deeply into that right now. But one of the considerations is going to be who on the team is going to be outside counsel and who on the team is going to be the internal team. You want to think about who from the general counsel's office is going to participate. And typically, if we have someone from the general counsel's office, we want to have someone who's in the relevant business unit that's affected, because they're going to be the person who's most knowledgeable about how that business unit operates and what we're going to be drilling down on in terms of subject matter, so that they can direct us to the right people who have knowledge about the information. And in terms of employees who are non-legal employees, I would say the same thing. Sometimes you spend a lot of time, and frankly waste a lot of time, looking around for the right person to give you information, and you find yourself talking to the wrong people, right? That's not a valuable use of the company's money. Having lawyers looking around for the right people. So if you have an employee, a non-legal employee who's sort of your tour guide to the company and can help you get to the right people who can provide you with information. Where are these documents? What do I care about here? Who can tell me X, right? Who can get me to the right group of employees who can provide me with information about Y? That employee can be a very useful person to the legal investigation. Another useful member of the team, if it's a financial information investigation, for example, will be an accounting type person, a forensic accountant, for example, who's hired by counsel and therefore can maintain the privilege. If it's a data breach type investigation or an investigation that involves IT information, an IT specialist on the team who again is hired by counsel and can maintain the private privilege in the investigation.
Prag, one of the items we want to talk about that's important for all of us, but I think especially important for you, is when you have to consider multiple jurisdictions. Now, with your location in the UK and proximity to Europe, I can only imagine how often that comes up. So when it comes to planning an investigation and building your team, what do you need to consider when you're touching on various different locales that might come up within an investigation?
Absolutely. Thanks, Regan. There's probably a few points that are worth touching upon here, and some of which very much overlap with the notes that Jordan and Michelle already touched upon. Firstly, the jurisdictional boundaries. What does that look like? And making sure you've got a grasp of that both at the outset of the investigation, but also as that evolves. To Jordan's point around planning, you can never stop planning. You need to be able to react to some of the facts, the information, etc., that you begin to unearth as you go about the scoping, as well as the fact-finding pieces, early stage, midway, and towards the end of investigations as well. Similar to what Michelle was talking about and what team is needed, there's central and local dimensions to that, and I'll explore that a little bit in a moment. But also the language and culture aspects, they shouldn't be overlooked, and actually we find looking at and working with, as we'll increasingly see, global multinational corporates and organizations that have an incredibly complex global footprint, not only regional. There's all sorts of issues that come up through that as well. So looking at the jurisdictional boundaries, for example, where your relevant entities, your witnesses, the location of evidence, all of which can lead to scoping discussions, and looking at that at the outset will help you assess the legal requirements that follow. Just to pull that apart a little bit, for example, identifying the application of local privilege laws and who to conduct the investigation to maintain that, what self-reporting may be required and in scope, particularly for regulated entities. And again, that can have a mosaic of considerations even within an individual jurisdiction. And also record keeping and retention requirements, as well as the intersection with local privacy laws, all of which are factors that may have local nuances. And when looking at on a cross-border basis, those factors, there's layers of additional complexity. And turning to whether you have a central or local team, thought as to who that team should comprise of, as well as, for example, the committee, the governance forms that are overseeing the investigation can also be really important to make sure you operationalize the investigation at the outset in a coherent way. Regulators, for example, also expect investigations to be credible, and the risks of disclosing reports without such credibility can lead to further activities later, such as regulators intervening and conducting their own investigations where this could have been otherwise avoided. And that credibility can be established through independent, conflict-free investigation teams, but also those on the ground, as Michelle says, that really know the corridors, that know the business and have the right skills, the expertise, the familiarity to understand and undertake the investigation in an effective and efficient way. And alongside that, using local team members and navigating how investigators communicate with the witnesses, access and review foreign documents, for example, and even report to management at all layers, which can be navigated at the outset if you use the right resource. Local languages, even dialects, can really make a big difference. They can make interview subjects, for example, feel all the more comfortable with the process, avoid ambiguity, and even maximize the chances of obtaining that accurate information, which you're always on the lookout for. And those cultural differences really, I think, should be borne in mind when undertaking your investigations on a complex and cross-border basis. And finally, dealing with regulators and law enforcement, we've touched upon it a little bit already. Understanding local regulator practice, I think, is really important. The enforcement risk and how to navigate that based on the nature of the allegations, as well as what's wider and trends and themes that are going on in any given jurisdiction. This can also help focus unwieldy or broad investigations, which have broad allegations.
Perfect. Well, thank you. All very important considerations. And as we've teased a couple times now, we're now going to move into our section on privilege, which I think for us all being lawyers, that's always a key consideration. And we know there's at least a couple types that come up, namely lawyer-client privilege, and of course what we call litigation privilege, but there may be others in other jurisdictions. So Prag, why don't we stick with you so you're not batting cleanup this time. What kind of privilege should we be keeping in mind when we're planning and conducting investigation? I know the four of us are coming from common law jurisdictions, UK, US, Canada. Thank you to the UK for passing on your legal tradition there. Are there any kinds of unique privilege that come up perhaps in some of the EU member states or elsewhere that need to be kept in mind? And what are some general considerations that you've got for us?
Yeah, absolutely. A really important part of investigations, as many on the webinar will appreciate. And just starting with a brief recap, your two principal types, legal advice or lawyer-client privilege alongside litigation privilege. Looking at the components of those, I think it's really important to bear those in mind. And as I touched upon on a cross-jurisdiction basis, that can really vary on what might look like a similar concept as a whole. But actually, when you look at the individual components, the breadth or the narrowness in application by the courts or investigators can throw up quite a few problems which can otherwise be avoided. And so looking at lawyer-client privilege, for example, you need that communication, written or oral, between the client and the lawyer, which is intended to be made in confidence, and for, of course, the dominant purpose of giving legal advice. And similarly for litigation privilege, very similar components, looking for that communication between the lawyer and the client, the sole or dominant purpose of litigation. But actually, when you look at some of those component elements, interestingly, you can see a great deal of variation with the application of that privilege. For example, in the UK, clients are actually interpreted incredibly narrowly, particularly in contrast to other jurisdictions. And this actually remains an area of potential change in the near future, where courts have been quite vocal and express in saying, were the Supreme Court in the UK to get their hands on this, there may well be a new interpretation of clients. Currently, it remains restricted only to individuals who are authorized to obtain legal advice on an entity's behalf. And this ties back to the point I made earlier around establishing a clear team where they're based, the governance and the investigation committee, which will then help drive and clarify from the outset who's investigating, who's instructing those lawyers to help maintain that privilege. Similarly, litigation, in the context of litigation privilege, has an interesting application. Many would expect a clear application, as is the case for court proceedings, but it's a little bit less clear when looking at regulatory investigations, other tribunals, inquiries, or similar. And for example, case law in the UK indicates there must be an adversarial element as opposed to pure investigative or inquisitorial. And the Court of Appeal decision, for example, has talked a little bit around where a prosecuting agency has made clear that there is the possibility of that criminal prosecution and legal advisors were in fact engaged. There was clear grounds for considering and contending that prosecution and therefore litigation for present purposes was in reasonable contemplation. And that makes all the more difference in considering whether litigation privilege is in fact in scope and very relevant in the context of complex investigations at the outset and what privilege might apply. Two others I'll briefly touch upon: common interest. Many hopefully will be familiar with this concept as well, essentially arising where party A voluntarily discloses a document that's privileged in its hands to party B. And as it says on the tin, really, that party B has a common interest in that subject matter of the communication or in the litigation in connection with which that document was produced. And what does this mean? Where this occurs, provided the disclosure is given, recognizing the parties share a common interest, the document will be privileged in the hands of B. So practically speaking, it concerns voluntarily shared privileged information and can be waived by the primary privilege holder. Finally, I'll just briefly mention, without prejudice privilege, this applies to exclude all negotiations genuinely aimed at the settlement of and giving evidence in that context. And this may be relevant, particularly where you're looking at related or parallel litigation, which can spawn either alongside or consequentially alongside investigations. And finally, again, just to underline the point, given the cross-jurisdictional nature of investigations we face and the different local privilege laws that may present challenges, no one-size-fits-all approach should be taken. It's important to bear in mind and actually navigate and map what jurisdictions, etc., are in scope to make sure that you navigate and best protect your position at the outset, but then every step along the way as well.
Thank you, Prag. Some great points there. And Michelle, just building off of what Prag just said there about setting things up at the beginning to, kind of maximize the protection of privilege. You're also coming at this from a unique perspective, obviously being in both the private practice side and the prosecutorial side. What thoughts do you have for how you can strategically set things up at the beginning to best preserve privilege, and what trade-offs are, maybe coming into play along those lines?
Yes, so from a DOJ perspective, if we find out there's been an internal investigation, we want it, and we want the entire thing, right? I mean, that's all there is to it. So having been at DLA and been on the other side of that, I know that, right? And under US law, the investigation is not privileged if the primary purpose is providing legal advice to the company. It is privileged if the primary purpose is providing legal advice to the company, but it's not privileged if it's just happening in the ordinary course of business, or if it's required by company policy or required by regulation. So putting that into context, if the company is just going along on an ordinary day and stumbles across something that looks abnormal, you might be able to argue that that is advice provided in the ordinary course of business. But if you receive a subpoena from the Department of Justice, right, it's going to be a little harder to argue that it was something that you stumbled across in the ordinary course of business, and is probably more akin to providing legal advice to the company. And so you might be on better grounds in arguing that it's privileged, right? However, you're always on better grounds if you get outside counsel, because you're always in a better position to argue that the outside attorney was providing legal advice to the company than that this was just ordinary course of business advice. So we typically, when we're stumbling across a problem that, as Jordan described, could have DOJ coming knocking on your door, it's better to have outside counsel doing the investigation. Or when we're stumbling across a problem, as Jordan described, where upper executives might be implicated, or when you're going to have a potentially high exposure situation or a public relations nightmare. Like, these are the types of situations where it's probably better to have outside counsel providing the advice for the investigation, because then you can argue the primary purpose of this investigation is providing legal advice, and therefore it is privileged. And so in those situations, obviously you want to be providing an engagement letter, the scope of which is the investigation, and that is the purpose of outside counsel. And if you're retaining people, you want counsel to be retaining those people so that the scope of those relationships are privileged as well. If you're retaining experts to provide expert advice relating to the investigation, counsel's retaining those experts, not the company, so that those relationships are privileged.
So why don't we turn to our third section, which is on data preservation and the collection of records. Of course, especially nowadays, so much turns on these voluminous records that you have available. I think email alone has forever transformed what many investigations look like. And in order to deal with that properly, of course, we, theme of the day, need to get a plan in place. And you definitely want to avoid, of course, unintentionally destroying or otherwise tarnishing the evidence that could prove crucial for your investigation. So this time, why don't we start with Michelle? What steps would you say organizations and their counsel need to take right from the outset to ensure that records and data are appropriately preserved, collected, and made available for review during the course of the investigation?
So right at the outset, we need to first know what is there. What do you have? What is the universe of documents and what is relevant to this investigation? And to do that, you first have to get to the right people who know the answers to those questions. And as soon as you know that, what is there, what is relevant, where is it, what form is it in, and sort of brainstorm with the people who know the answers to those questions, then you need to capture it immediately in the form of a litigation hold, which makes everyone's blood run cold. I don't know. I don't understand why this is coming from the government. I don't understand why companies are so resistant to this concept, because to me as a prosecutor, the worst possible thing that can happen is destruction of evidence, right? Destruction of evidence is a crime. So let's make that not happen, because then you have exposure to prosecution, and we don't want evidence to be destroyed. So we want all of our employees to know, let's not destroy evidence. We want to have a conversation with everybody who should have documents on this subject matter that we're investigating, a rattle our brains conversation where we're trying to think of the whole universe of people, really rattle our brains so that we don't come up with Joe Blow down the hallway who we should have thought of but didn't 3 months too late, because now he's had the opportunity to put things in the shredder or delete his entire email. We also want to find out, what are the retention policies of the company? Do they have auto delete of all emails after 3 months? If they do, we're calling the IT guy and we're turning that off so that we are preserving, right? The whole idea is to preserve, because we're doing an investigation. We want to find the smoking gun before the government finds the smoking gun, so that we can decide what we're going to do about it. That's a topic for a little later in the presentation. But we want to figure out what are the parameters of every set of pieces of information we have, whether it's electronic or paper or however our information is stored. And then the big thing that the US government is concerned about, and my department in particular, is ephemeral messaging, right? We are all communicating all day, every day, and a lot of us are communicating by text and DM with our coworkers about work, and a lot of us are doing that on our personal devices because our companies don't want to pay for our communications. They say, hey, why don't you use your personal phone, and we will give you a stipend toward your personal phone, or we will give you a really cool quarter zip jacket, or we will give you a puppy if we don't have to pay for your phone. And so everyone's using their personal device, or they're using sometimes a device that the company is giving them, and it has Teams messaging, or it has WhatsApp, or it has other things the government hates, because the communications disappear automatically in 3 days and all of our evidence goes out the window. We hate those things, and so we punish you. We punish you for using them because we believe that you are trying to hide evidence by using those things. And so they are strongly discouraged. They are considered to be messaging systems that are less desirable. And so companies are encouraged to use the types of communications that retain rather than dispose of evidence. So we want to look at that when we're doing the investigation to figure out what is the lay of the land and how we're going to collect all of this stuff and preserve it.
Thank you, Michelle. Some great insights there. Once again, I love that we're getting kind of both sides of this here. So Jordan, why don't we turn specifically to forensic IT specialists? When you've got a bunch of complex digital evidence involved, what role does a forensic IT specialist come that might actually surprise people, everything they do?
Yeah, forensic IT specialists are usually a part of most of our investigations at this point in time. I think one thing to note is that there's a difference between a digital forensics expert and some really awesome people on your IT team. And so while IT professionals do a great job of managing a company's infrastructure and making it so when people like me are like, I can't get into Excel, they can fix that for me. They don't necessarily have the skill set to do a proper digital forensic image or analysis, and certainly not one that might be legally defensible in court. So you're going to have to think about that, and again, weigh the costs and the pros and the cons, but usually I recommend that you engage a proper forensic expert to at least preserve and extract that data. I'd also say I'm a big fan of over-preserving. You can always decide later on, you know what, we preserved Susan's data, but turns out we don't actually need to look at Susan's stuff. The cheap part is the preservation. The expensive part is the analysis. So kind of to Michelle's point, I'd rather over-preserve and not look at it than under-preserve and realize down the road we've missed something really important. Quick point on litigation hold, and I'm going to disagree a little bit with Michelle, and maybe I think it might be a Canadian thing versus a US thing too. We generally would not send out a litigation hold notice on our investigations, especially where there's a sensitivity. So, I do a lot of fraud recovery litigation. So if I'm hunting somebody who's misappropriated funds from the company, I don't really want to broadcast that because I want to do it secretly and then freeze their bank accounts. So, in that type of situation, we wouldn't set up a litigation hold. But I'll make the pitch again for our IT people because they can do a lot in the background to put in place those holds for us. So much of our information is now electronic. So we can set up litigation holds in the background that avoid deletion of those emails, that avoid deletion of those documents, and make sure all of that is preserved. Analysis is a whole different story for a whole other day. But the short version is that we've got amazing AI and analytical tools nowadays that have avoided what me and Pragesh and Michelle did in ancient times, which was look at each individual document. Now the supercomputers can run through this stuff and find that needle in the haystack way better than we used to be able to, way more cost efficiently, given the volume of documents we're dealing with.
Perfect. Thank you. Some great tips there. Prag, why don't we turn back to you? Because something else we have to consider when dealing with all of this data and information is what data protection and privacy law considerations come into play. And what can you speak to on that? And I imagine it's especially challenging for you where, once again, you're dealing with potentially multiple different countries in close proximity with different laws and regulations.
Absolutely. And many on the call who had any proximity relationship with the UK or EU footprint a few years ago will remember the pain that was the GDPR implementation projects that were taking place. And so whilst this could be a section and topic in and of itself, I'll keep it brief with some of the key principles that I think are worth bearing in mind here, alongside what is now a slightly more mature data privacy framework across the EU as well as in the UK. So point number one would be transparency, the minimum requirement to inform individuals about how their personal data is being used, unless there's an exemption, of course. This should be made and provided in a clear and accessible manner. Now, this may well already be in a more generic privacy notice that's already provided in a general sense, which may then also have specific content for the use of personal data in internal investigations as disclosed to external regulators as well. Alongside transparency, we have data minimization. The use of said personal data for an investigation should be proportionate. It should be documented so that you can demonstrate what principles have actually been applied. And that's a general principle for a lot of decision making, a lot of investigation activity, making sure you document those decisions in certain contexts, and making sure that you have a clear go-to source and trail essentially to look back to see, why did you take this decision? Why did you take that turn in the road? Why were these documents ultimately then, having initially been preserved, destroyed, for example? Establishing a legal basis for processing personal data, also incredibly important. Again, those familiar with GDPR implementation projects will be familiar with the concepts of consent and legitimate interest, and making sure that we're adhering to those. And finally, two other points which I'll mention. is at looking at special categories of personal data. So personal data being a category in and of itself, but then within that special categories, how you treat that, the legal requirements there, all of which wrap into the additional complexity when looking on a cross-jurisdictional basis. Unfortunately, with GDPR across the EU, we have a degree of harmonization there. But if you are transferring or accessing data which is from outside the EU, many organizations have not just EMEA footprints, but outside of that. Ensuring you have a legal basis for that data transfer in and of itself, also really important. There are, of course, some exceptions to these requirements. And again, this can be incredibly nuanced. And whilst I won't go into the vagaries of all of these, because it can be incredibly complex, and using data privacy experts in this point in juncture for input and analysis, incredibly valuable. But essentially, you'll want to look at what existing data privacy notices organizations have, because that will set the foundation for what you can do with future investigations, as well as practically considering how you process, how you handle, access, etc., that data. So all factors to be borne in mind, and actually building a little bit on what's been touched upon, the use of notices and when should they be provided. I think a really important point to bear in mind as a tool for also slipping in your transparency, your data minimization, and giving your employees an understanding for how that personal data is being used. And it's a good opportunity to reinforce what may be a controller process in wider investigations, but then also feeding into that your data privacy risk management steps, essentially by providing further notice, further clarification on those points around transparency, those points around data minimization. And indeed, from a cooperation perspective with local authorities, this can also be quite important, and understanding how data is being used for certain witnesses and when you're interviewing. But we'll talk on that a little bit more in the interview section coming up. So just to close off on two final points, looking at certain information and prohibitions, in fact, so flipping this slightly and saying, not just what can we do with certain information, but what shouldn't we be doing in other contexts. So for example, in the UK and certain other EU jurisdictions as well, if you're obligated to report for AML purposes or other legal requirements, it can actually be good practice to report to other organizations as well, for the benefit of that self-reporting piece. And again, data privacy principles will feed into what you do and what you report on so far as personal data goes. So again, important to look at that intersection and how one feeds into the other. And also, whilst on the topic, avoiding tipping off, this is a more general point, not just on data privacy, but looking at that in the context of investigations and making sure you're not inadvertently tipping off, which, for example, in SFO guidance in the UK makes quite clear there's a danger with tampering with evidence, and that's inconsistent with your principles of cooperating with the regulator.
Absolutely, some great points there. Well handled, Prague, especially what, as you said, that probably could have been a whole webinar plus just on itself. And as you so nicely already started the segue, we're going to move into the interview section. And of course, Michelle, with your impassioned points earlier about the value of prosecutors and people who've been on the law enforcement side when it comes to interviewing and investigating, why don't we turn over to you? What are your thoughts on how interviews should be approached when an organization is looking into some sort of misconduct?
All right. So just to touch on the last question, I do agree. In terms of litigation holds, you certainly don't want to do one if you haven't outed the target of the investigation, and you don't want to do that through a litigation hold. I'm referring more to the situation where the jig is already up and you need to preserve the evidence. But in any event, in terms of interviewing, determining who to interview should sort of be done in stages, right? First, I think it's important to do a scoping type interview to get kind of the lay of the land of who might know what, so that you're not kind of going down unnecessary rabbit holes. I think I've seen people who kind of have this idea of let's interview everyone. You don't have time to interview everyone, and it's a waste of time to interview everyone. So if you can identify a key person in the department who has knowledge of the issue, who can sort of say, this person will be valuable to talk to, this person won't be valuable to talk to, the people in this unit know about X, Y, and Z. That's a worthwhile 30 minutes of your life to just sort of, that's like a lay of the land, or what we call scoping interview, that can help you focus your time well. I tend to interview the complainant first, because that's how this all started. If there's a complainant, I tend to interview the target of the investigation last. Why? Because I want to interview that person when I have the most information in my back pocket as possible, so that I can tell if that person's lying to me because I have other information that maybe that person does not know I have, or thinks they're getting one over on me, and I happen to know they're not. So that person is usually the last person to come in the series of interviews. And again, I want to have the person conducting the interviews be someone like myself, or like a law enforcement person who has a lot of experience doing interviews, because it's not a typical conversation. I also think a really important skill is knowing when to stop, right? And that's true in law enforcement, and it's true in internal investigations as well. There is a time when it is no longer valuable to keep investigating, and you just have to say, okay, we have what we need, we're done here, the end. And not just keep going and going and going and going. At some point, you're done. And a good investigator knows when that is.
Thank you. Some great words of wisdom there. Prag, why don't we turn back over to you when it comes to scheduling these interviews and then starting them off? What kind of notice needs to be given to those interviewees? And any considerations that kind of change, once again, from jurisdiction to jurisdiction?
Of course, generally prudent to provide that notice, but as we've already touched upon and explored, there may well be reasons for taking a slightly stealthier approach, looking at asset freezing orders in the background to make sure you're getting sight of assets and keeping a hold of them before you notify interview subjects. For example, from a UK perspective, we have our ACAS investigations guidance, and it's considered best practice to provide reasonable notice. But again, that can vary jurisdiction to jurisdiction. Having an understanding of those requirements, I think, is really essential, and mapping them before you embark on either notifying or even thinking about notifying, how you go about doing that, whether there's any particular form or substance requirements. And in close relation to that, whether we're looking at interviewees being entitled to counsel or union representation, that closely straddles what that notice looks like for it to constitute valid notice. For example, where there are more stringent requirements at a local level, and this is where intersections with employment law, guidance, etc., can all feed into that, and the nuances on a jurisdiction by jurisdiction basis. And similar to that, what kind of explanation should you be giving? To Michelle's point, at the earlier stages in the scoping context, you want to be giving a degree of information, but certainly not diving into the nitty-gritty, not giving too much away, so that you can maintain a strong position in navigating the direction of the questions, the information that's provided, and make sure you continue to retain control. But also, I think, had that clear focus on the scope, those terms of reference that you planned, agreed with investigation committees, governance forms, etc. at the outset, to keep it really tight and focused as you undertake these interviews. And finally, worth mentioning is an Upjohn style warning. Many clients do ask, is it advisable? Is it inadvisable? I think delivering this is generally considered best practice and helpful. This is something that originated in the US, where the lawyer essentially warns the witness that the lawyers are representing the company, not that employee or witness. And touching upon the privilege points made earlier, that privilege belongs to the company, not the employee. So it's the company that can waive that privilege should it choose to wish to, on a limited basis or otherwise. And you'll hear more about that later in the series. And finally, the investigation is confidential, and where appropriate, the interview is in fact a fact-finding exercise.
Jordan, anything to add on those key points, Pragesh, meant from a Canadian perspective, perhaps?
No, I think Prague has covered kind of the stuff that we would certainly cover. Upjohns are always a question we get, especially when we have US-based clients. They're wondering if we're going to do Upjohns. Upjohns aren't required in Canada. But our legislation, we don't have any case law that says you got to up-John anybody. But we would certainly do it for some key people. But kind of going to the other end of the spectrum, our scoping interviews and some of those people that really aren't involved in this, we wouldn't necessarily up-John them because it sometimes can make things a bit awkward and chilling, and we're not required to in Canada. So that would be the only nuance I would add.
One fundamental thing that I think people sometimes don't actually think through enough is actually recording the questions and answers you are going to be asking and having answered during the interview. So what trade-offs and thoughts need to be thought through when it comes to how you're actually recording the interview itself?
Yeah, sometimes people will ask me if I'm going to audio or video record an interview, and I'm not a big fan of that. I'll give you my pitch as to why I don't do that in my practice. First of all, I worry about privilege. So I think if you have an audio recording of an interview, that is just a recording of facts of something that happened. And I think that there could be some arguments to be made that might be producible, depending upon who did it, especially if you have somebody that's a non-lawyer doing it. There's a recent case, I think, out of Alberta, where those audio recordings were ordered to be handed over because they were held not to be privileged. And I wouldn't want to see something like that happen. I think it also puts a bit of a chill on the interview. I think people get a little nervous when they think they're being recorded. So I don't like it from that perspective. So generally my preference is some very detailed note-taking. I unfortunately do not have the skills to take notes and do interviews at the same time. So I always have a separate note taker come with me whose sole task is to take detailed notes that we can use for the purposes of our reporting. And not just basically making a transcript. I don't need a stenographer there. I need somebody who's not only taking in what's being said, but making notations as to body language, tone of speech, delay, impressions as to credibility and the manner of response, follow-up items that we might want to consider with other witnesses. And when you include things like that in your notes, they really become defensible from a privilege perspective, because now this is not a documentation of what one person said to another person. It's legal impressions as to the case. And so that helps protect it even further from privilege. So there's Jordan's pitch on why I don't like recording. I welcome what Prag and Michelle have to say about recording of interviews, but my general answer to clients is no, I don't do that.
Michelle, any thoughts along those lines?
Completely agree to not recording interviews. Just don't think any good can come from that.
I'd echo both. Interesting that we do sometimes see clients who insist on it, actually. And there may be certain contextual reasons for that, whether it's in the context of an inquiry and they want that degree of transparency. And that is as transparent as you can possibly be, I think, when you have a recording which is played out in open inquiry, hearings, proceedings, etc. But generally speaking, on the side of caution and wouldn't go for recording either.
Now, from the government side, I would love to have your
there we go.
recorded interview of your client. So please be sure that someone non-legal is involved in taking that recording.
Appreciate your transparency, Michelle, and swapping back and forth between both hats. Wonderful. All right, so for our final section, why don't we fast forward kind of to the end of the process, or which we really should always begin with the end in mind. What does reporting look like? And also playing off that, what do we think about when it comes to self-reporting? And then, of course, the roles of whistleblowers. So there's a lot to talk about here, and unfortunately not much time left. But Prag, why don't we turn it over to you to just speak briefly about some of the key considerations that organizations and investigators might face when they're determining the kinds of reporting that should come out at the end of an investigation, or maybe simultaneous investigations.
Sure, happy to kick off here. I think we've touched upon some of these points already, but certainly no one size fits all. I think really important to bear in mind the context of the investigation, what you intend to get from the outcome, as well as where it may end up. You've got a range of audiences to think about here, right? You've got your boards of directors, your equivalents, your employees, complainants, and what updates as well as final outputs you give to them, the subjects themselves, investors, regulators, the likes of Michelle, of course, a range of stakeholders that you have to be thinking about. And all along the way, not just at the end in that final report, once everyone's really poured over the details and agonized, you've got the updates along the way, and considering how privilege applies, how you defend that, etc. All key considerations. Very similarly, limits on disclosures, thinking about how your confidentiality, your privacy, your privilege, all of that feeds into the mix for what you want to strategically do, and think about your options for what you do with those reports, what those self-reports may look like. The mediums as well, an important part. And I think over time, we've seen an evolution from written, verbal to hybrids, whether it's your PowerPoint slides, whether it's your specific committee meetings and providing that verbal update. And obviously there's trade-offs here, and you have to think about, on the one hand, the clarity that you get from written, clearly articulated, documented findings, legal advice that comes with that, and the remediation options that you'll need to be thinking about. To the risk of inadvertent or possibly advertent leaks, something we do see and you do need to bear in mind, and the trigger of disclosure obligations that then follow off the back of that. And certainly, for example, if you have regulated organizations within a wider group, again, across different jurisdictions, there's all sorts of requirements that come to that, for example, in the financial markets of your listed entity. And remembering those audiences and those ultimate recipients at the various stages, I think, is something everyone should bear in mind for risk management around reporting, self-reporting.
Thank you, Parag. And building off what you just said there about self-reporting, why don't we turn it over to Jordan? And I know, Jordan, this is very context specific, but what are some thoughts that need to be worked through when it comes to the question of to self-report or not to self-report?
Yes, that's always the tough question, and it's a tough choice, and it's often needs to be made at a very early stage. So that makes it even tougher. So let's take our Canadian Competition Bureau. Unless you're the first one knocking at the door, you're not getting any benefit out of the Competition Bureau. So, in that instance, where you're dealing with, say, a price fixing or something like that, you're running to get ahead of everybody else, often with not a lot of information, right? So that's certainly a challenge. With any of our self-reporting, the OSC, the ASC, they talk about reporting as early as possible, making a timely report. So you're always balancing that. You want to make the early report to meet the criteria that's set out for credit for cooperation, but you don't have a lot of information to make that decision on. So it's kind of the worst possible situation to have to be in, and we just try to balance a multiplicity of factors. I'm not going to list them all here because there's so many, and as you mentioned, Regan, they're very context specific. But let's go through a few. How likely is this conduct going to make its way to the regulator? Is there a whistleblower who's going to be knocking on the regulator's door if you don't deal with this? Or is this something that has come to you through some sort of internal process that you think you can manage? If you think you can manage it internally, you might try to take your chances and not self-report and hope that the regulator never finds out about this and you can remediate internally. But if this is going to be disclosed, you want to get in front of it. You want to be the one to knock on that regulator's door and not the whistleblower. So that's, one factor that might come into play. In terms of self-reporting, we come back to, and we do it over and over again, privilege. So if you're self-reporting, almost all of the regimes in Canada are going to have an expectation from the regulator or law enforcement that you are not going to hide behind your privilege. The Ontario Securities Commission and the Alberta Securities Commission both include language in their policies as to cooperation that effectively say, here for the OSC, they won't provide credit where a market participant claims a privilege to avoid providing details of potential breaches of Ontario securities law. I don't know how much more clearly they can say it. We don't expect you to rely on privilege, and if you do, you may not get credit for cooperation. So, going back to our plan, going back to thinking about privilege, you may be in a position where you're going to self-report, where you're really not going to have any privilege to protect. And that might change the way you do some of your investigation and the way you proceed with your matter. So there's so much to consider in self-reporting that I don't think I've done it entirely some justice, but those are some of the key points that you would want to be considering.
Wonderful. Thank you, Jordan. And Michelle, obviously, once again, we know this is something that you've got experience with and exposure to from both sides here. What can you tell us about both self-disclosure and whistleblower incentives, whether that be from the Department of Justice or other entities in the U.S.?
I will end with a commercial for the U.S. Department of Justice. Last year, we rolled out our voluntary self-disclosure program for corporations, which provides incentives for self-disclosure. Self-disclosure being reporting as early as possible when the misconduct is discovered, showing remediation efforts, and complete cooperation with law enforcement, including disclosing all relevant documents and identifying all wrongdoers. And the benefits of that are potentially include that the corporation may not have to plead guilty itself, and that if it does have to plead guilty, that there would be a reduction in sentence, and no corporate monitor, which is a big benefit to many corporations. More recently, last month, the department rolled out its corporate whistleblower program, which I know has generated a lot of buzz. And that program provides incentives for whistleblowers if they provide non-public information to the government. There's a potential for them to get a percentage of the proceeds of forfeiture, where there's forfeiture by the government of more than $1 million. They can get a percentage of the net proceeds of the forfeiture up to 30% of the proceeds for the first $100 million, which is a significant benefit. And that's designed to fill in the gaps of whistleblower programs where there aren't any. So, for example, we already have a whistleblower program related to the False Claims Act. This would not double up on that. This would be separate from that.
Thank you. Wonderful commercial, by the way. I'm sure
Thank you.
The Department of Justice is happy to have you back. Finally, Prague, why don't we jump real quick over across the pond again, and want to quickly weigh in what sort of whistleblower and self-reporting programs might there be to kind of keep in mind over in the UK, EU?
Sure, and interesting to see the UK regulators, particularly with changes in leadership in the enforcement departments quite recently over the past year, begin to look to the regulators and compatriots across the pond and say what's going on over there from an incentives point of view, and making actually a lot of noise around whether the UK will follow suit. So for example, the SFO just last month at the Cambridge International Symposium further nodded to their indication that they were looking at incentives in a whistleblowing context. I know the FCA are also looking at this. So it'll be very interesting to see if they follow suit on the whistleblowing side of things, as long have the regulators here consider that an important source of market insight and intelligence, and indeed lots of historic enforcement action has been off the back of whistleblowing tips. But I do think regulators have to be careful with using incentivized whistleblowers. The credibility, for example, particularly later stages, and if witnesses do then suddenly become unavailable, there's genuine challenges with the credibility, the wholesomeness, and the evidence that may be decisive in terms of the investigation in the case and the book that a regulator has built. But alongside that, I'll touch a little bit on quite a large scale change that's been taking place, and clients with a UK and EU footprint will have been, I think, closely observing. But the whistleblowing directive has been implemented in local law, and so lots of clients have been grappling with what you would have thought at a high level is a harmonized whistleblowing regime, but actually working with colleagues across our European offices, lots of nuance, lots of fragmentation to that. And this touches back upon the question of, do we need to use local resources? Do we need to use, and can we use central resources? Something which operationally obviously has cost implications for clients, but also the way in which the prescribed approach to handling whistleblower complaints in particular on certain reportable topics, as well as actually being far more transparent around who and how whistleblowing reports can indeed be made, not just internally, but also through external channels, and flagging and signposting those external channels in internal corporate policies, procedures, and documentation. So interesting developments to see how, on an operational level, whistleblowing is being further incentivized from a legal perspective to meet policy objectives around getting that information from those types of sources.
Very interesting. Well, thank you for that, Prague, and thank you Michelle and Jordan, all for your input today. It's been a very illuminating panel. We, of course, well past time here, so I think any comments abated in the chat, we're going to have to reach out by email to get back to you. But we do thank everyone for attending today and participating, and look forward to reaching out to you directly to answer any questions. Jordan, why don't we turn it over to you briefly just to send us off and into the rest of the symposium.
Yeah, thanks, Regan. So before we wrap up today, I also personally want to thank Michelle and Prague for joining us. We really appreciate your insights. Just a quick note, we have 3 more webinars coming up in our symposium this month. On October 9th, we have Preparing for the Unexpected, one to do when the regulator comes knocking. On the 16th, we have a hot topic in Canada here, modern slavery in Canadian supply chains. And we wrap up our series on the 23rd with the Privilege Protection Plan, a step-by-step guide. So make sure you RSVP or subscribe to our subscription list so you don't miss out on any news or updates about these upcoming webinars. We hope to see you there, and thanks everybody for attending. Have a great day.